Oh. Instead, she has raised a number of further allegations against the respondent without giving any unnecessary detail. She says that she was raped in a hotel at a work function about 6 months before her resignation, that she was drugged beforehand, and that this was orchestrated by senior people at the company, that afterwards she was intimidated into silence via means of various threats and by her arrests, which were coordinated by the respondent. Other allegations range far and wide and include human trafficking and drug trafficking, even that she was sexually assaulted while in custody by the police officers who arrested her. Even this is said to be only the tip of the iceberg. None of these allegations, however, had been raised in the claim form. This section of the judgment is factually inaccurate, misleading, and demonstrates bias towards the respondent. The judge incorrectly states that the date of my rape as 6 months before resignation. The truth is that I was drugged and raped on the 3rd of January 2023, a fact well documented in contemporaneous police reports. Misstating such a critical date minimises and undermines the seriousness of the sexual assault and signals a lack of impartiality. By framing my allegations of rape, intimidation, and collusion as further allegations and suggesting they are somehow extraneous or irrelevant, the judge implicitly discredits my credible claims, despite their relevance to constructive dismissal, sex discrimination, and harassment claims. This is a clear example of bias in favour of the respondent, contrary to the Employment Tribunal's duty under Rule 3 of the Employment Tribunal Rules of Procedure 2013, which mandates that proceedings are conducted justly and fairly, ensuring parties are able to present their claims fully. The judgment refers to allegations of human trafficking, drug trafficking, and sexual assault while in custody, in a manner that trivialises and sensationalises serious criminal misconduct, again demonstrating prejudicial and dismissive treatment of the claimant. All of these allegations are grounded in evidence I have submitted to the police and the tribunal, and their inclusion is necessary to demonstrate the pattern of harassment, collusion, and abuse of process by the respondent and their associates. The judge further claims these allegations had not been raised in the claim form. This is misleading. Certain allegations could not be included in detail due to procedural limitations and ongoing criminal investigations, not because they are false or irrelevant. The tribunal should have considered amendments under Rule 11 of the Employment Tribunal Rules of Procedure 2013, which allows claims to be amended to ensure that all relevant matters are adjudicated. Legal and procedural implications. Misrepresenting key facts of a sexual assault constitutes a serious breach of procedural fairness and raises concerns under Article 6 ECHR Right to a Fair Hearing and common law principles of natural justice. Dismissing the relevance of criminal allegations of collusion, harassment, and witness intimidation prejudices the claimant's civil claims, particularly under Employment Rights Act 1996, constructive dismissal and whistleblowing protections, and the Equality Act 2010, sex discrimination, harassment. Such treatment also risks undermining Rule 3 of the Employment Tribunal Rules of Procedure 2013, which obliges the tribunal to deal with cases justly, including ensuring that parties are able to participate fully and have their evidence considered. Conclusion. The misstatement of dates, trivialisation of my claims, and selective framing demonstrates clear bias in favour of the respondent. I will be appealing this judgment on the basis that the tribunal has misrepresented critical facts, disregarded evidence, and failed to apply the rules of procedure fairly, undermining the entire adjudicative process. It's probably also worth mentioning here that I didn't state that I was sexually assaulted in custody. I reported that I was sexually harassed in custody, which I was multiple times, including in my own home during my arrest and in my cell multiple times. So that has been amended in a letter I wrote and sent later on. But I was a bit rushed in sending this, so that's why. So, among all this, Miss Ashwell did confirm that she is no longer at her previous address and would like all future correspondence to be sent to her by email. The only clue to her whereabouts was that a family member had told the respondent that she was in Portugal based on her location data, even though Miss Ashwell had tried to throw the family member off the scent by telling her that she was in Italy. She also accepts that her electronic and data storage devices have been seized by the police. This section again shows clear bias and improper framing by the tribunal. It states that my whereabouts were disclosed by a family member, but in reality, the respondent received information from the police about my location. I deliberately provided two different locations, Portugal and Italy, to test whether people were continuing to collude about me, which they clearly were. Within days, Chris Robshaw and Camilla Kerslake appeared in Portugal, and Camilla subsequently posted about being in Italy. This is not coincidental. It constitutes a deliberate attempt to intimidate me. While it is true that I did not attend the hearing, this was not an act of evasion or contempt. I had repeatedly requested remote access and was refused fair participation and was not given a safe or impartial environment in which to attend. This is a procedural failing of the tribunal, not deliberate non-compliance on my part. I currently reside abroad for my safety following retaliatory arrests, police misconduct, and repeated stalking by Camilla Kerslake. At no point have I intentionally evaded lawful instructions or fled an investigation. The tribunal's use of language such as off the scent wrongly implies evasion, which is entirely false. Such framing is improper for a judicial decision and risks prejudicing the tribunal against me, contrary to Rule 3 of the Employment Tribunal Rules of Procedure 2013, which mandates impartiality and fairness. Furthermore, the respondent's apparent fixation on tracking my private location is deeply disturbing and amounts to further intimidation and harassment, potentially breaching the Protection from Harassment Act of 1997 and my rights under Article 8 of the Human Rights Act 1998, right to a private and family life. Such conduct is incompatible with the principles of good faith expected of a litigant in civil proceedings. Additionally, the seizure of my electronic devices by the police does not diminish my credibility or rights. It is wholly inappropriate for the respondent to leverage that fact to portray me as evasive.